Tony, one of the things that, or various things that I think a consumer needs to know, um, are what it takes to qualify for a bankruptcy, be it a Chapter 7 or a 13. And I think that we should probably just talk about 7 or 13, which is the consumer protection bankruptcy. And we're not talking about Chapter 11 for businesses or anything like that. So if you had to go ahead and explain what a person needs to do to qualify for a 7 or a 13, what are the key questions? What are the key elements? What are the things that they need to know in order to go ahead and qualify?
I think the very first question that needs to be asked is, how many people live in the household?
Why?
Well, it's pretty important. It comes down to what's called in the industry a means test.
Okay.
And what that does is it lets the system know if you have X amount of people living in the home, you have an exemption up to a certain amount of money. For example, if you're one person, your total amount that you can make in the household is, for example, $3,600. Versus if you have five, that might jump to $5,000 or $6,000.
Okay.
It all depends on what the means test says today, and also depends on your state in particular area.
And the important thing is that means test number, that figure that you're talking about, let's say $3,600 for one person living in the house alone or whatever, that changes every few months.
Yes, it does.
And that's important to know too, because sometimes a person qualifies perfectly well for a certain chapter. Let's say it's Chapter 7, which is the one where you come in and the one that most people want to go ahead and qualify for. You're in and out within 3 to 5 months. You don't pay back anything to anybody.
Correct.
But sometimes they qualify, let's say now, and then 6 or 7 months down the road when the government changes the numbers again based on poverty levels and stuff like that, then they don't qualify. So it's important to know those numbers going into it and what are the trends more or less. What else is important for them to understand and to know when they're trying to qualify for a bankruptcy?
Well, their income. I mean, it goes back to what we talked about, the means test.
Yeah.
They really need to know their income, and depending on how many people live in the home. For example, if you're married, does your spouse work?
Mm-hmm.
If you have children, do your children of 18 years old age or older,
Mm-hmm.
where they actually contribute to the home financially? Maybe you have a grandparent that lives in the home and they receive some type of retirement, Social Security. All that is income for the household.
And all that factors in to the portion of the household compared to the gross monthly income with that means test and the whole thing. So,
right. For example, it doesn't matter that the entire house is not filing bankruptcy. It could be just one person. However, everybody's income has to do with how your means test is going to work out.
even if they're not going to be applying for a bankruptcy.
Exactly.
Because I've seen that too, where a husband and wife, and one will say, no, I don't want to do it.
Correct.
And they can. The person can go ahead and file for bankruptcy individually, but it usually requires questions of the attorney. And I think that's an important part too, that a lot of people think they can do this on their own. And the bankruptcy courts, the federal system, they try to put a lot of information out there to assist these consumers to probably try to do the petition on their own. But I don't think it's something that I necessarily recommend. At least you got to get a consultation with an attorney.
Absolutely. It's not smart to try and do this on your own. Everyone that's tried to do this on their own, I want to say 95% of them end up with an attorney, because the disaster that they create on their own for not knowing the rules, it's incredible. And the problem is that once you start, getting out of that problem is huge.
It is.
So
it is.
It ends up costing double, triple, because now the attorney that comes in has to work that much harder, and it's going to charge you that much more money had you just gone to him or her in the first place.
You know, one thing that the consumers usually don't look at is how much they have in debt. I always tell clients or people that interview with me to find out about this information on bankruptcy is that find out how much it is that you owe. Because let's talk numbers. What are the average fees and costs associated with a bankruptcy? And it's very simple. For a Chapter 7, an attorney is usually going to charge anywhere between $1,500 to $2,500 for a Chapter 7. Yeah, and the $2,500, it's not like a random figure. It's called the safe harbor fee, which means that a court will not question that fee being charged by an attorney. So they usually charge up to $2,500. Whereas with a Chapter 13, the safe harbor, the maximum that you're looking at is usually about $3,500 to $4,000, depending on the state that the consumer lives in.
Right.
So at least they go in knowing more or less what it's going to cost them. And now that brings to light the question that I was going to say now, which is, or answer now, which is sometimes clients come in, or sometimes they're seeking a bankruptcy, the consumer, they're looking for all this information, and they only have like $5,000 or $6,000 in debt. And at that point, you got to weigh, the odds and say to yourself, well, wait a minute, I owe $5,000 or $6,000, and I'm going to have to pay an attorney $2,500 to wipe out all that debt. Why would I want a bankruptcy on my record to begin with? So even though they may qualify perfectly well for a bankruptcy, there will be times that we don't recommend a bankruptcy.
No, I 100% agree with you. We see it very often. We see it mainly with the elderly, where they want to file bankruptcy because, unfortunately, the retirement money and the money they're getting pension-wise just isn't enough, and they perhaps loan their credit card to a grandchild, and that grandchild went crazy with it, and now they owe $10,000. So they think, okay, well, I need to file bankruptcy. Well, not in every case does an elderly person need to actually file bankruptcy.
And it really depends on the state that you live in, I mean, for instance, let's use Florida as an example. Florida has certain exemptions that exist by constitution and by statute. You're talking about the grandparents, they're receiving a pension.
Correct.
That's completely exempt. A creditor can never touch that. What does that mean? That if Capital One, Visa, MasterCard, whoever it is, American Express, they sue that particular elderly person that's receiving a pension, they would never be able to touch that money to begin with.
Correct.
So there's no need to do a bankruptcy at that point. You're going to be spending $2,500 to basically die with a medal or a badge on your shirt when you're in the casket that says, I died with an 850, when in reality, you didn't have to pay anything. You would have died perfectly fine anyway, so to speak,
Exactly.
without having to pay that creditor. Is it something that is recommendable to everybody? No, but at least have that knowledge going into it that not every case is a bankruptcy. But question, what about the cars? What about if a person owns a car?
Well, that's very important because it all depends on the value of the car. For example, if you have a car that's worth $4,000 or $5,000, you're filing solo, you rent, you don't own, there's certain exemptions where you're going to be able to keep that car. However, let's say you have the car and you lease it. Now you have to reaffirm that lease. It sits outside of the bankruptcy. If you fail to make payments, because it sits outside of the bankruptcy and you can't file bankruptcy for another 8 years, now they have a way to come after you. So you have to make smart decisions when you file for bankruptcy when it comes to things like cars, homes. If you have extra other homes, you got to make a decision. Do I want to keep it? Am I going to be entitled to keep it? What negotiation am I going to have to do with the trustee to keep it? These are all factors that people need to know, and having proper guidance and the proper material is important.
And that's where this kind of information comes in handy for that consumer that's studying the different options, and they're looking around the internet right now.
Exactly.
And they're saying, I need to go ahead and get all this information. Another point that I see is that a lot of people really don't understand the bankruptcy process. They think that there's a judge involved, the court is involved, and that's not necessarily the case.
Correct.
The one who actually administers the majority of the bankruptcy process is known as a trustee. And as soon as that petition for bankruptcy is filed, whether it's a Chapter 7 or whether it's a Chapter 13, that trustee is going to have a meeting of the creditors with that debtor. Now, what does that mean? It's not that all the creditors are going to show up. It just means that the trustee has to sit down and ask questions of that debtor on behalf of the creditors, because the trustee doesn't represent the debtor.
But however, is a trustee in essence a judge? Because that's everyone's question. When they hear the word trustee, they're still thinking judge. Is that person an actual judge?
And that's a great question. And I think in reality what it is, it's almost kind of like the role of a magistrate. And you say, well, what's a magistrate with respect to a judge? A magistrate will give recommendations to a judge as to what should happen in a case after they've heard the evidence, after they've accumulated the information. And that's pretty much what a trustee does. The judge is going to be dictated, or the judge is going to give a lot of deference and a lot of leeway to the trustee and go based off of his or her opinion as to what should be done in a case. Not all the time, though. There are bankruptcy safeguards. There are safeguards that are contained in the code under the bankruptcy regulations that give debtors and consumers the right to fight back if a trustee says, no, I want that car. It's not exempt. I want to keep that car. But there are certain provisions in the bankruptcy code, and also depending on the state in which you live, that will protect that car, but you need to argue it forcefully. And obviously at that point, it'll be before a judge because the trustee doesn't agree with you. Again, let's remember, the trustee doesn't represent the debtor. The trustee represents all the creditors that the debtor placed on that bankruptcy petition.
So hence, the reason that the trustee would want to push to keep that car, push to take certain money out of a bank account, push to take away someone's jewelry or furniture is because they get a percentage of that money, I'm assuming, that they're able to accumulate for that creditor.
Money talks. I mean, the trustee, as part of their compensation for administering the bankruptcy estate, the creditors have to pay a certain portion to that trustee for finding assets, for selling off those assets, basically for administering everything on behalf of the creditors. So yes, they do receive a certain percentage, and it really depends on the state where that bankruptcy petition is being filed. And it's not like something that the consumer has the right to pick a state. Okay, the consumer has to live in the state for at least 2 years in order to go ahead and take advantage of the exemptions that are provided for the bankruptcy petition in that particular state. Very simple example, Florida offers an exemption of $4,000 wild card exemption.
I was just going to ask you about that.
If you rent a home, you're entitled to an additional $4,000 that you can sprinkle around all your assets however it is that you want. But you got to be living in the state for at least 2 years. You just can't move from Georgia to Florida and then the following month file the petition for bankruptcy and think you're going to get that wild card exemption. No,
It doesn't work.
Doesn't work that way. You got to be living in the state for at least 2 years, and then you'll receive all the exemptions and all the benefits of the exemptions of that particular state, depending on how it is that there's the interplay with the bankruptcy law and the states. That brings up to our attention the concept of federalism and how it is that these bankruptcy laws combine with state laws. It's an interesting process, but at least I think this gives a head start to the consumers to get some sort of information. In terms of receiving a discharge on the bankruptcy, it's probably, if you do a Chapter 7, it's probably going to happen within, give or take 5 or 6 months, before you're able to discharge all that debt that you can discharge. As opposed to a Chapter 13, you're going to get the discharge as soon as you finish the payment plan, which could be between 3 to 5 years. And there's formulas to determine how long it is that you're going to have to pay these particular debts based on your disposable income. But again, at least this gives the consumer a head start on what to look for.
Is it true that most people that do a Chapter 13 fail the Chapter 13 within a short period of time and end up in a Chapter 7 bankruptcy anyway?
Yeah, it's funny that you should mention that. At least in Florida, I'm going to use Florida as an example. South Florida, as a matter of fact, the Southern District, which encompasses West Palm Beach, Broward, Miami-Dade, and Monroe County, 85% of the Chapter 13s that are filed by consumers fail within the first 10 months, which is why I discourage, in particular, filing for a Chapter 13. Maybe sometimes with proper planning, with the proper instruction and guidance, you can go ahead and qualify for a Chapter 7. It's such a common thing that occurs with that 13 being converted over to a 7 that they have special forms in this particular district, in the Southern District of Florida, that accommodate automatically. You have to use those particular forms because so many people fail in the Chapter 13 repayment plan that they already have a process, very, very expedient process in order to get you into a Chapter 7.
Well, I think this is fantastic information. And I think a lot of people are going to benefit from this information. And I think that if people want to learn more, where could they learn more?
Oh, Legal y Real. That's the best place to look at. That particular website, that particular Instagram, that particular Facebook is there to educate the common man about how the laws work. Bankruptcy is just one of those modules. And obviously we give much more information, not just on bankruptcy. We talk about mortgage foreclosures, we talk about credit card debt, we talk about wills and trusts, we talk about everything necessary, even things that don't necessarily affect consumers. We even talk about elections and how it is that these things work. We're here to go ahead and educate the public and help them get along in their search for information to make the right decisions.
So just like in the name Legal y Real, también hablamos español.
También.
Perfecto.